I remember my last words to them. When they were getting out of the car, I made sure they had sweatshirts, and I told Libby I loved her.
What did she say back?
She told me she loved me too, and that she'd see me later.
Central K, 2 missing juveniles last seen at the High Bridge in Delphi, Indiana, at approximately 1300 hours on 2/13 of 2017.
Two 13-year-old girls went missing hours ago, and we're told they haven't been answering their phones ever since.
This is the entrance here to the trail where they were last seen. They weren't answering their text messages or phone calls. Libby's grandfather tells us the search started right away.
We started going through all the social media things, picking up, looking at Facebook. Has she talked to anybody, or had the girls been talking with anybody, Snapchatting or whatever the kids do today back and forth. And really didn't find anything. The last message I think we found going out was like at about 2:30, which was like a Snapchat of a picture of them out there on this bridge on the trail system. And that was the last communication we've had.
The images on Libby's phone form the bedrock of this entire deception. From the very beginning, they were strategically seared into our collective subconsciousness by way of repetition and emotional manipulation, irreversibly influencing the mass perception of this event. Honestly, nothing short of psychological warfare that happened here. Even though these images originated by a third party on social media, and they display clear and provable signs of digital alteration, their authenticity continues to avoid the necessary scrutiny that such evidence warrants. To question their authenticity, though, is to not only question the heroic dying act of a 14-year-old murder victim, but also to suggest a much larger conspiracy, including family involvement and law enforcement impropriety. And such a suggestion would not be entertained or tolerated in Carroll County. But now it's no longer in debate that at least the image of Abby on the bridge was not taken by Libby on her device at 2:07 p.m. on February 13th, 2017, as established at trial. In the search warrant for Ron Logan's property, FBI acknowledged the BG video found on Libby's phone. But they curiously never referenced these images, which purport to capture the last known whereabouts of two murder victims, within close proximity to their target, Ron Logan's residence. These images would absolutely be included in that warrant if they were recovered from Libby's phone. FBI knew these images were not authentic evidence, just like they knew that this was a pagan ritualistic sacrifice based on their review of the physical evidence at the crime scene. Those of us who studied the Snapchat images with discernment realized this as well due to photographic anomalies such as pixel distortion and manipulation, incorrect body proportions, as well as misplaced highlights and shadows. What may have been a decent enough Photoshop in 2017 is honestly a laughable attempt in 2025. All signs pointed to the conclusion that these images are not authentic photographic evidence of the last minutes of Abby and Libby's lives. And if you pull on that string, well, that leads to many more questions that the state and those close to the victims who have positioned themselves as above reproach would rather avoid. And for the most part, they unfortunately did. On March 12, 2024, the defense addressed the suspicious origin and questioned the reliability of these images in a motion to compel and request sanctions filed by Andrew Baldwin. He wrote, "There are two images that exist, but which the state of Indiana has not turned over to the defense. Those images can be found on the internet, with at least one of those images seemingly adopted by law enforcement as being legitimate as it has been utilized by law enforcement in various media appearances, including a 2019 press conference. We are talking about the photo of Abby Williams walking on the bridge purportedly taken at 2:07 on 2/13/17, attributable to being sent via Snapchat from Liberty German's phone. Also, an image of the Monon High Bridge purportedly taken at 2:05 p.m., also attributed to being sent via Snapchat from Liberty German's phone. Related to those items, the defense would ask the court to compel the state of Indiana for the following that so far has not been produced. 1. Interviews or reports of Kyle Smith or anyone else that received either or both images taken on the bridge purportedly at 2:05 and 2:07 p.m., purportedly from Libby's Snapchat. 2. All reports, analysis, and documentation detailing any information about the images purportedly taken at 2:05 and 2:07 p.m. and sent out via Snapchat. 3. All reports, documentation, and analysis from Snapchat or any law enforcement agency dealing with the data confirming when those images were taken, where they were taken, and how they were distributed, including all reports related to the data and metadata. 4. Any analysis related to those images that has been conducted by any law enforcement agency or by any person or governmental or private entity that has worked with law enforcement. And lastly, if the state of Indiana does not believe that the image of Abby walking on the bridge at 2:07 p.m. and the bridge taken at 2:05 p.m. are discoverable because the state of Indiana does not claim those images as relevant or reliable, then the defense requests confirmation of the same. The state responded saying basically everything we have is in your possession, and they failed to specifically reference these two photographs. At trial, it was revealed that this image, which represents a very critical component of the state's timeline, was never found on Libby's phone or in her Snapchat cache. Instead, the phone recorded activity at 2:07 when it was unlocked and Snapchat was accessed. It appears that the narrative builders just inserted this image into that time slot. ISP Sergeant Christopher Cecil was forced to admit that he found the photo on the internet, just like the rest of us did. He did not have an explanation for why the photo was not saved in the cache. Allen's attorney, Jennifer Auger, pushed back on this inconsistency, proposing the possibility that someone else may have posted it from another device. But this challenge seems to have fallen on the deaf ears of the jury. Pretty much all courts have special rules that govern the admissibility of evidence. Federal courts have federal rules of evidence, and state courts generally follow their own similar set of rules of evidence. These rules promote accurate fact-finding and resolution of disputes on their merits ahead of time. This enhances the efficiency of the legal process and ensures the rights of all parties, especially the accused, are protected. A violation of rules of evidence occurs when a piece of evidence is presented in court that does not meet the legal standards for admissibility, meaning it is considered irrelevant, prejudicial, unreliable, or obtained illegally, and therefore should be excluded from the trial. In Indiana, a violation of the rules of evidence can be grounds for a new trial if the improper admission of evidence substantially prejudiced the opposing party and affected the outcome of the case. Here, at least 2 of these evidentiary violations occurred in the state of Indiana versus Richard Allen, when the state was allowed to present this image as evidence at trial. Specifically, Rule 901 dealing with authentication and Rule 1002, otherwise known as the best evidence rule. Before evidence can be admitted and shown to a jury, it must be properly authenticated, meaning that it must be shown to be what its proponent, or the party bringing forth the evidence, claims it is. Examples of evidence requiring authentication include documents, photographs, and recordings. Authentication can be achieved through various methods such as witness testimony, expert testimony, or distinctive characteristics of the evidence itself like metadata. Rule 901 requires the proponent, which in this case is the state, to produce such authenticating evidence. Here, when the defense requested details, reports, analysis, and metadata concerning the origin and reliability of these images, the state failed in its requirement to produce such authenticating evidence per Rule 901. Therefore, this image was not authenticated, and the trial court erred when they failed to compel the state to provide authentication of origin and reliability and prevent this image from coming in if they failed to do so. Moreover, Rule 1002, the best evidence rule, requires that when the contents of a writing, recording, or photograph are at issue, which here they are, the original must be produced unless it is unavailable for some reason. This rule is specifically designed to prevent inaccuracies and fraud that could result from relying on copies or oral testimony about the contents of a document or photograph. Sergeant Cecil admitted that the image was not found on the victim's phone through an extraction, and he did not have an explanation for its absence. He further admitted that he based his analysis and testimony concerning this evidence on an image he found on the internet. When the defense raised these issues on March 12, 2024, and no copy of the original extraction was produced, the best evidence rule was violated, and the judge should have ruled that this evidence was inadmissible at trial. As such, the admission or mere reference to this photograph at trial was in clear violation of Rule 901 and Rule 1002 of Indiana's Rules of Evidence. But this isn't just an evidentiary technicality, as the mere implication that these images were fabricated and staged for deceptive purposes leads to a disturbing conclusion. If this image was fabricated and planted on social media, which would explain why it wasn't found on the phone, then the state's timeline and narrative completely detonates, exposing that bedrock of deception that this entire lie was built on. Acknowledging this deception also compromises the integrity of a lot of people and calls the actual events of that day into question. This image in particular serves a unique purpose because it pairs the victims with Libby's phone, which includes the GPS ping, Apple Health data, BG video, and Snapchat stories, most of the evidence the state built their entire case on. This includes the schematics and timeline of how they say the murders happened. Without this image, the state would have to contend with the fact that anyone could have been using Libby's phone to stage a false timeline. Let that sink in. This most likely fabricated and planted image is the only nexus linking the phone to the victims that day, which is why the state had to bring it in. Besides this Snapchat image and Kelsey's word, the state relies on two other forms of evidence to show the girls were at the trails, let alone alive, on February 13th. These are the Hoosier Harvest Store CCTV footage and Betsy Blair's testimony, both of which are inconclusive and based on unproven suppositions, and as such, contain plenty of reasonable doubt. For example, the start of the state's timeline is based on Kelsey's unsupported word that she dropped the girls off at the trails that afternoon. The state attempted to corroborate Kelsey's claims with the Hoosier Harvest Store footage, which apparently showed a vehicle quote-unquote matching Kelsey's heading westbound on 300 North at 1:49 p.m. However, this is inconsistent with initial reports of when they were last seen, as well as Kelsey's many public statements that she dropped them off at 1:30. This 15 to 20 minute difference raises doubt that the vehicle in question was actually Kelsey's. The camera was too far away from the road to properly capture any conclusively identifiable features, such as the license plate or individuals seen in the vehicle. As such, this footage is insufficient proof of the girls arriving at the trails at 1:49 p.m. Even if the vehicle could be adequately identified as Kelsey's, this does not prove that the victims were in that vehicle. There is no CCTV footage that captures the girls anywhere near the trails that day. Betsy Blair's testimony that she saw two girls walking towards High Bridge that she believed to be Abby and Libby is similarly inconclusive. There were multiple groups of girls around the girls' age who testified that they were on the trails on that day and time. For example, Bree Wilbur places herself at the trails at the same time as Betsy Blair's 2 p.m. sighting. Bree Wilbur is Kelsey's best friend and uncannily resembles Abigail, as they both have a heart-shaped face, straight auburn hair, and a slender stature. Kelsey's whereabouts after dropping the girls are also never corroborated, and there are numerous parking locations and trail access points. Bree Wilbur and Kelsey German could have easily been mistaken as Abby and Libby. Betsy Blair did not know the victims, and she does not conclusively claim to have seen them. Rather, she claims to have seen two girls walking, and she believed those two girls to be Abby and Libby. Betsy Blair's belief is not a proper identification and also does not serve as proof that the girls were at the trails that day. So while everyone was so focused on proving that Richard Allen was at the trails that day, only a few of us have ever challenged the unproven supposition that the girls were at the trails. As I have just laid out for you, the evidence is insufficient to conclude that they were, rendering Allen's presence at the trails on that afternoon completely innocent and unrelated to the murders, a position he has maintained since the day he reported, voluntarily and in good faith, back in February 2017. Remember that it's not in debate that Allen was at the trails that day, rendering most eyewitness testimony entirely irrelevant. But Allen's presence at the trails is not incriminating because of the state's failure to place the victims there. And unfortunately, the defense did not challenge this. See, what cops and prosecutors did here was quite clever. They Frankensteined a scapegoat based on the image they extracted and manipulated themselves from the video on Libby's phone, combined with an array of eyewitness descriptions. They advertised this figure to the masses as the lone killer, his appearance generic enough to cast a wide patsy net. They then operated on the unchallenged belief that this faceless character they called BG is the sole murderer of Abby and Libby, and it happened at this location within this narrow window of time. They ignored, dismissed, and destroyed evidence that did not favor this narrative. They refused to test forensic evidence found on a victim simply because they believed the hair to be a female and as such, not relevant. They straight up cleared people based solely on their likeness to BG or ability to produce an alibi during this arbitrary narrow time frame. They withheld all information from the public that this surely involved a group of people, assuring the community was safe that this was an isolated lone killer attack. And this may sound ridiculous, but where is due process for BG? I must remind you that it has never been proven that this guy, 1, is a real person, or 2, committed any crime. It's not like they're saying he pulled out a knife and stabbed the victims in the video. In that scenario, then sure, matching your suspect to BG would be extremely incriminating. It's like they skipped the step of proving this individual to be the murderer, but simply added a sentimental story hailing the victim as a hero. This was just adopted as fact in the court of public opinion. The state's timeline is not based on scientific evidence such as a medical examiner's time of death, credible witness statements, or authenticated photographic evidence. It's based on a made-up narrative which is only supported by planted, unreliable evidence. And I gotta say, I remained puzzled why, among all the brilliant legal minds looking into this on behalf of Richard Allen, nobody really thought to question the evidence found on Libby's phone, especially given the blatant violations of evidentiary rules I cited earlier. Not just for the purpose of destroying the state's narrative, but challenging these items is critical in uncovering the truth of the matter. If those images cannot be authenticated, which they were not, then someone fabricated and planted them, and the state intentionally omitted and obscured the origin of this evidence. Ironically, the piece of evidence that the state built their entire case around is, in and of itself, evidence of third-party involvement, as well as investigative and prosecutorial misconduct. That is a very uncomfortable conclusion and frankly loaded accusation that I fear lawyers are hesitant to make. But it's gotta be done.